Hello friends, welcome back to VOW DAYS. Welcome to the mains test series discussion. This is part 4 of test 9, and sorry guys, we have not been able to upload videos in the past few days because of some health issues that we had in our team. So from today we will be regular again. So let us quickly start with the discussion. So 16th question. What we have is with regarding to the anti-defection law. Just a second. Yeah. So anti-defection law. So we all know anti-defection law is dealt by the 10th schedule. The 52nd Constitutional Amendment Act in 1985 has introduced this anti-defection law. So this talks about the disqualification of members of the House of any political party if the member voluntarily gives up his membership of such political party or votes or abstains from the voting against the whips issued by the political party. This is the thing. And also, if the nominated members do not join the political party, within 6 months, then they are also eligible for this, or they can also be disqualified under this anti-defection law. So this anti-defection law is one of the important thing to answer or you can say it is to ensure stability in the Indian political system. This is basically to avoid the horse trading and all, because we have been seeing in the recent times and all, after the elections, the MLAs from the losing party are jumping into the party that is winning or the party that is having majority. This we are seeing. We have seen in many states, Madhya Pradesh, Maharashtra, and we have seen like that. So these are the examples which we can quote in the exam as well. So the main intention of this anti-defection law is to stop this horse trading and all, but because of the issues in this law, we still are seeing such instances. Now, the issues that this anti-defection law will address are: it prevents political defection, strengthen democracy, and make the member of parliament and legislative assembly more responsible. It ensures that the members selected in the name of party by its support base remains loyal to the party and its policies. It also will uphold the will of the people. The floor changing after being elected is basically betrayal of the people who have elected them. Now, this anti-defection law has various issues. The issues are: with not enough room to harbor the difference of opinion, it enmasses departure of rebel legislators become the political normal. It can bring governance to the grinding halt. So basically there is a difference between defection. There is a difference between this defection and difference of opinion. There is a difference between these two things. So this actually has to be addressed by this law, because the legislators are not having freedom to express their views openly, because they are bound by the whip, the decision given by the whip or the whip issued by the party. So they don't have the freedom to raise their voice or raise their concern. So this is basically against the basic meaning of democracy. Also, the merger provisions which are there to safeguard the member of parties where the original party merges with another party, subject to the condition that at least 2/3 of the members have to agree such merger. So if you see this, basically, though it is stopping the defection, but it is encouraging the mergers. So the defection is turning into mergers, because at the end of the day, everyone wants power in the politics. So this power can be ensured through these mergers. The party which lost can merge with the party that has won, and they can simply come into power. Also, it will punish the legislators for switching parties, but the parties have no liability. They are accused of inciting the legislators of rival parties to switch the loyalties, leading to political instability. That is also true, because without knowledge of political parties, such defections will not happen. It focuses on voluntary defection and remains silent about the expulsion of members from the party. Once expelled, such a member would then be an independent in the House with an option of joining another party, a possible loophole for the exploitation of the law. So this is the thing. So after expulsion, the person who is there, he will be an independent member, and then he can join another party very easily. So this is another loophole in the law. And the presiding officer will decide the disqualification on the grounds of defection, but the presiding officer is not politically neutral. He did not resign from the party from which he is elected. So these are the issues that are there. Okay, so if there is a question on anti-defection law, we have to write all these points. Now let's look at the next question, the 17th question. This is with regarding to the powers of the parliament. Article 245, 255, Part 11 deals with this. The legislative relations between the center and state legislative between the state. The legislative subjects are under union, state and concurrent list. The parliament has exclusive power to make laws with respect to any matter in the union list. Example, defense, foreign affairs, atomic energy, banking, communication, etc. The state legislature in normal circumstance make law on matters in the state list. Example, police, public order, public health and all. But both parliament and state legislature can make laws with respect to the matters in the concurrent list. For example, education, trade union, marriage, etc. So, with regarding to the separation of powers, we can say everything is clearly defined. On the union list, the center will have power. On the state list, the state will have power. But on the concurrent list, both of them will have power. But if the state passes any legislation and after that the center will pass another legislation, then the center's legislation will overtake the state's legislation. So the state legislation then will not have any value. That we have to remember. And the number of subjects in union list is more. Union can make laws over 100 subjects, but in the state list we have only 61 subjects. In the overlapping between the union and state or the union and concurrent list, the former will prevail. In the conflict between the center and states with respect to the subject and concurrent list, the central law will prevail, which I just told you, and the power to make laws on residuary subjects lies with the central government. Residuary subject means the matters which are not there in all the three lists. So the new matters, for example, let's say artificial intelligence, for example, the new 5G. So these are the new kind of technologies and new things that will be emerging with time. So these new things which will be emerging with time will not be there in any of this list. So then the central government will get that residuary power to frame a law with regard to these subjects. Now, what are the powers of the parliament to legislate on the state list? Under 5 circumstances, the parliament can legislate over state list. First is when Rajya Sabha pass resolution with 2/3 of majority, 2/3 present and voting on the grounds of national interest under 249, then parliament can make a law on the specified matter in the list. But this has a validity, this will be there only for 1 year. During a national emergency, again the parliament can legislate over state subject. During the state emergency, that is during the president's rule, even then the parliament can make a law on the state list. Okay, when the constitutional machinery in the state has broken down, then also it will happen. And also when two or more states ask the center to make a law through a resolution by the state legislature, then also the parliament can make a law under article 252. Okay, so and also this will be applicable only to the states which has requested, not to all states. Along with this, with regarding to implementation of various international agreements, international treaties and conventions, the central government will have more power. So these are the various times during which the central government or the union can make this thing law over the state list. Now let us move on to the 18th question, the next question, and this is with regarding to the gender gap in judiciary. Gender gap is something which we will see in all the fields. The women participation in the workforce is about 24 to 25% only overall. So the women participation in the workforce is very, very less. So obviously we can expect the number of women to be less in all the fields, from politics to judiciary to all the other jobs, the scientists and everywhere. But there is a fact. The number of postgraduates or the number of women who are doing post graduation is much more compared to that of men. That is also there. So there is some issue overall. We have to address these things, these gender specific things, because gender sensitivity and gender empowerment, these are very important concepts even from the examination point of view. Well, they are important anyways from society point of view, but from examination point of view also they are very important. So if we see the gender gap in judiciary, so even this question came directly in 2019 or 20. Just check once. This question on women in judiciary came directly. Yeah, this is in 2021 it came, not 20, in 21. So the CJI has called for reservation of girls in legal education, underlining the need for more women representation in the profession. So what are the benefits that we are going to have if there is wider representation of women in judiciary? First, it gives democratic legitimacy because it enhances the court credibility and representativeness. There will be diversity in it. The voice of the different sections of the society will be heard. It includes public confidence on the judiciary, because whenever we see a woman judge or a woman at higher authority, we generally have this tendency that we will feel that we are in safe hands. It enables younger women to seek and aspire to flourish in profession and improve gender balance therein. They bring to law different perspective. They build upon their understanding of the different impacts of certain laws that have men or women. So that's why the woman being in the judiciary is very, very important. But since its inception in 1950, we had only 11 women judges, out of which 3 have been appointed in 2021. Till now, there is no woman CJI. Only 83 women judges out of 680 judges in the high courts, and 30% of the women judicial officers in the subordinate court. So this is the situation of women in the country. Even the situation of women lawyers in the country is not any better. Out of 1.7 million advocates, only 15% of women. So this is the scenario of the women in all the fields. Especially this is the data that we can remember for judiciary and just using the exam. Now the reasons for this underrepresentation of women. The first is patriarchal attitude. Second, the judicial infrastructure is very, very big issue. Lot of courts do not have toilets. They do not have restrooms, childcare facilities, and 22% of the courts do not have separate women washrooms. So that's a very, very big issue. And these are the issues that are there in the hands of the government. These are very small issues that can be solved very easily, but still those are not given priority. Even the gender disparity in the Supreme Court collegium can be seen. Barring Justice Rumapal, no woman judge has made it to the Supreme Court collegium of the senior most judges to oversee the the appointments in the high courts. Along with these things, there is another issue. Generally, women take a gap during their pregnancy time. Though now we have these laws which actually protect the woman, but still, this career gap is something that is affecting the promotions and everything of the woman. So this is something that the women are facing. So that is the thing. Now, what are the measures to bridge gender gap in Indian judiciary? The first is the judiciary and the society needs to be sensitized about the benefits. There should be transparent collegium. They ensure that the names forwarded for the appointment are purely based on the merit and no patriarchal mindset should be there. Incentivizing the girls to opt for legal studies and empowering them, giving them reservation, and this gave encouraging results in the appointments of women at district level. The superior judiciary should have horizontal reservation for women without any dilution of merit. Utilizing the vacancies, 387 seats out of 1104 sanctioned strength in the High Court are vacant. So these are the things. Now let's look at the next question, which is about the Indian Constitution, the 19th question. The Indian Constitution differed from its contemporaries in various ways. Although its drafting initiated under the limited sovereignty, it resulted in Constitution and it is perceived to express high degree of sovereignty internally and externally. And also another important thing, if you see, like Indonesia and Sri Lanka, Indian Constitution drafting began before the independence as per the Cabinet Mission Plan. But the transfer of the government power from the British to India happened in June 1947, and this removed the procedural constraints imposed on Constituent Assembly under the Cabinet Mission Plan. This gave them more freedom, and as all of them have experienced what is going to be the issue if proper rights are not given to the people, Indian Constitution was framed in such a way that the people are empowered. The Constitution is framed in such a way that the rights, duties, and the measures are balanced. Indian Constitution was written under the intense disagreement with respect to religious and national vision, plus the grave need for economic development. Despite this, the outcome of the drafting process resulted in establishing a successful democratic order. In Indonesia, democratically elected Constituent Assembly will be dissolved by the President decree, which reinstated and established authoritarian regime of guided democracy. Indian leadership perceived the national unity and legal uniformity necessary, and the social and economic modernization is also important, just like Indonesia, Sri Lanka, and other post-colonial divided societies like Turkey. Many governments did not allow the open deliberation in constitutional process, but Indian Constitution had intense negotiation of 2.5 years, where the Constituent Assembly was stronger and more confident and united around its leadership. So that's the thing. And also Indian Constitution borrowed all the important features from all the important constitutions and ensured that nothing is left. The Indian Constitution is something which is very dynamic, and that's why it is called as living document. And why it is called living document is because it actually changes according to the changing needs. So when the needs changes, then the constitution will be amended. Now let's look at the next question, the 20th question, which is tribunalization of justice. So tribunal, if you see, it is a quasi-judicial body set up by the Act of Parliament or state legislature under 323A or 323B to resolve the disputes. Tribunalization of justice, driven by recognition that it would be cost effective, accessible, and it gives scope for utilizing expertise in the respective fields. But it is a cause of concern for us because tribunal at the end of the day is not a court. It is controlled partly by executive against the separation of powers. It is controlled partly by executive, and this is against the separation of powers, Article 50. And also the executive will perform adjudication under this. It compromises the superiority of constitutional courts like the high courts and all, because the tribunals basically are just the statutory bodies. So, and also if you see, the constitution protects the independence of judiciary with respect to the qualification, mode of appointment, tenure and all. So the judiciary generally will have more independence in the way they function, but the tribunals, if you see, they are controlled by the executive, which is in power. So when the executive will have control, then obviously the politics will enter into the picture. This is what we are seeing. And also the Law Commission in 272nd report said that there is high pendency of cases even in the tribunals. The main intention of the tribunals is to ensure that faster justice. But if still the tribunals are not able to deliver this, then their main or the main reason for the creation is getting diluted. The Law Commission in its 272nd report titled Assessment of Statutory Functions of Tribunals in India has suggested following steps. Qualification of judge. In case of transfer of jurisdiction of High Court to the tribunal, the members of newly constituted tribunal should possess the same qualification as that of the judges of the High Court or the District Court. Appointment of chairman and members of the tribunal. So for this, what they said is that the vacancies in tribunal should be filled within the 6 months prior to the occurrence of vacancy. That means if let's say someone is getting retired in maybe June or July, so prior to that only, that means by January the new appointment has to be made. Because nowadays if you see the tribunal, the main issue is the large vacancies, the delay with respect to the appointment. So this is leading to the large vacancy, and this is impacting the performance of the tribunals, and their main motive is getting destroyed. The performance is getting impacted. Now the selection also should be impartial. There should be minimum involvement by the government agencies, as the government is party to the litigation, and there should be separate selection committee for this, comprising of judicial and administrative members. The provisions for tribunals order to be challenged before the division bench of the High Court with the territorial jurisdiction over tribunal in its appellate forum, since the judicial review is the basic structure of the Constitution. Similar recommendation was also given by Supreme Court in the L. Chandra Kumar versus Union of India case in 1997. Also, there should be regional benches so that the people can have easy access to the judges where the high courts are situated, and this is something which is very, very important. So these are the various things with regard to the tribunals, how they can be reformed and all, and the issues as well. Right? So these are the 5 questions for the day. We will meet again tomorrow with the next set of questions. If you have any queries, do write to us, or do leave in the comments. Okay, if you have any suggestions, do let us know those as well. Okay, so that's it guys for this lecture. We'll meet again in the next lecture. Till then, keep studying and stay tuned. Jai Hind.